If you are arrested for a domestic violence charge in Indiana, your case starts moving immediately. The no contact order is the trap that gets most people in even more trouble. In the next few minutes, I'm going to explain what happens after a domestic violence arrest, the timeline, bond conditions, no contact orders, and what you should do to protect yourself even before your first court date. After a domestic violence arrest, the court will set bond conditions quickly, meaning they'll put them in place even before you post that bond so that when you do post the bond, you have to abide by them or it can be a basis for a bond revocation. The biggest one is usually a no contact order, and that can apply even if that other person, the protected person on the no contact order, wants to talk to you. It can apply even if you live together, even if you're married or have kids together. It still applies. When you're released, you will get paperwork about that no contact order. Keep it. Don't guess about what it means. It may restrict texting, calling, face-to-face contact, indirect contact, meaning you have someone reach out on your behalf. All of that applies. So make sure you understand exactly what that means. And it's simple. No contact means no contact. And a lot of judges will tell you exactly that. So your first court date, that's not the end of the case. That's the beginning of the case. Usually it begins with an initial hearing. Sometimes that's waived and it starts with a pretrial conference. That's, again, the beginning of the court date. When the state starts to turn over the evidence, the court sets certain conditions, deadlines, the case begins moving forward. A lot of people think they had that trial right away because that's what you see on TV, but that's not the case. So what happens after that first court date? There's going to be evidence and an investigation. Domestic violence cases often involve conflicting stories. They're oftentimes he said, she said, he said, something like that. So the police are often put in a position where they have to decide which party they believe. And that doesn't mean they always make the right decision. Oftentimes they don't. A lot of times they'll look at the first version of events they hear. Maybe one person talks, one person doesn't. That oftentimes means the person who told their story is going to be the victim, and the person who didn't talk, for whatever reason, will then be charged with the crime. We see that very often. So it's important that we get any photos, any video that may exist out there. And we'll get that from the state, body cam, their version of events. We get all that, but you may have evidence too. So anything you have, we need to know about so we can decide if it's going to be something that helps build your defense. Other examples would be medical records, text messages, witnesses who were there who maybe didn't give a statement. All of that we need to know about. So what can you do to make this case worse? We already talked a little bit about it. Do not contact the person on the no contact order, because what happens with that is you'd be committing a new crime called invasion of privacy. Even if the person wants to have contact with you, text messages, if they're in the car with you going somewhere, all of these things can be used as both a violation of your bond to put you back in jail and as a new charge for invasion of privacy. So even if the domestic case is something we think we could fight, the invasion of privacy becomes so much more difficult to fight because they don't need the other person to cooperate. The police can just say, we observed them together. There was a no contact order in place. That constitutes a new crime. And that makes it so difficult. Posting online. Don't do it. Don't post about the person. Don't do anything that's going to make them more upset. Please just don't. Another issue would be talking to the police again. You will never talk yourself out of trouble. It's just not going to happen. Anytime the police are saying they just want to hear your side of the story, don't do it. They just want to get more evidence against you. You will never clear this up for yourself. That's where we step in. So what should you do? First, follow that no contact order. Second, save any evidence you have, text messages, photos, anything like that. Write down what happened while it's fresh. We see the police version of events and we see the victim's version of events. We want your version of events so that we can compare it to start to figure out what lines up and where there may be inconsistencies that we can fight. Give us all the names of the witnesses involved because we need to talk to them as well. And then talk to a defense attorney early before this gets so far out of control that we can't bring it back together. Because witnesses, they can be difficult to track down. Your memory, it can blur. Things can happen if you don't get started on this right away. So it's important to talk to a defense attorney right away. If you were arrested for domestic violence in Indiana, give us a call because there's a good chance we can help. We'll explain what happens next, what the no contact order really means, what your best strategy is going to be before you make a mistake that could create a new charge. So give us a call at 317-632-3642. Remember, always plead the fifth.